All right, well, we'll go ahead and call our next case, which is the Lester matter. And Mr. Chambers, you may proceed when you're ready. Good morning, sir.
Good morning. May it please the court, opposing counsel, my name is Bill Chambers. I am the attorney for the former wife, the appellant in this action. If I may, I would like to reserve 5 minutes for my rebuttal. This case, although it has a somewhat long and convoluted history, the issue framed by the appellant today really boils down to one matter, and that is whether or not $135,000, which was paid by the former husband toward a debt prior to the party's dissolution of marriage, should or should not have been credited to him in connection with the issue framed in the former wife's second motion to enforce. The second motion to enforce simply, at its base level, asked the trial court to evenly divide the proceeds from a settlement with American Healthcare and to distribute those proceeds between the parties. It was never disputed factually that the former husband had always controlled those funds, and in fact, at the time of the hearing, the former wife had literally not received a penny of the over $700,000 which had been paid. I would use, before I get into the specific basis...
Now, this $135,000, you're saying that the $135,000 is the same $135,000 that was netted as a result of the sale of the OCA stock?
Yes, Your Honor. The final judgment...
The net after taxes from the sale of the OCA stock was $135,000, and we know we're talking about the same $135,000, right?
Yes, Your Honor.
Okay, so that money was paid over to DPI.
Yes, sir.
Okay, who apparently there was some indebtedness to DPI, right? Okay, and then you're saying that when the AHC, the American Healthcare matter, was settled, there was a pool of money that was recovered by the former husband.
Yes, Your Honor.
Half of which belonged to her net of expenses, and that he expensed the same $135,000 again.
Yes, Your Honor.
And that's your beef, right?
Yes, and part of...
I don't understand what this whole Dr. Marshall Lakeland note is. You know, I got to tell you, this is a very confusing agreement to read. You know, it was written obviously for the parties that, you know, were intimately familiar with the facts, instead of written, you know, with an eye towards somebody that knows nothing about it, reading it and understanding what it means. And that, you know, that's, I can understand the trial judge's frustration with a settlement agreement, and I know you didn't have a hand in drafting it, but what's the Dr. Marshall Lakeland note about?
That was that was income to the parties. That was a receivable. And what happened was, with that note, at the time of the party settlement agreement, there was essentially three lawsuits which had existed. Two were still pending. One was DPI, which was a lawsuit against them, indebtedness. One was the AHC, American Healthcare litigation, in which they were the creditor, so it was favorable to them. And then there was a second DPI, which we, in the case, called DPI Coral Springs, obligation that had already been resolved. The Dr. Marshall Lakeland note was a receivable that was paid. My client was entitled to half of it, but the former husband was entitled to take part of my client's half and make the monthly payments on the DPI Coral Springs obligation. And I agree that it's the final judgment is somewhat confusing, and although I have maintained and we maintain in this appeal that the trial judge misconceived a number of things about the $135,000 and did commit error, I would certainly concede that it was confusing, and I have to accept some of the responsibility. I think the litigants' attorneys have to accept some responsibility for that, although that doesn't change what I believe is clear in the record. And like I said,
if he got a double, if she got whacked twice for the same $135,000, why isn't she just entitled to half of that 135?
Well, and that's the fifth issue raised in the appeal is that...
And that 135 would have belonged to both of them, right?
From the American health care proceeds, yes.
Both of them, really, right?
Right, and that is our argument that $67,000, she was short of $67,500 because the former husband was, quote, given that credit of $135,000. So yes, I agree, that's all she was entitled to, because had that $135 been in the pool, so to speak, then only half of it was hers anyway. And I completely agree with that. That is our argument.
Does the record disclose whether or not the sale of the stock that was sold was a marital or non-marital asset?
No, I don't think so. It's not clear, and the appellee's argument is that the former wife failed to prove that point, to present evidence of it. I would submit that it's completely and utterly irrelevant. The trial judge certainly focused on it.
Help me kind of just, let's focus on that 135, and just help me, if you can, understand how it would change if it was marital or non-marital, if at all.
Well, I don't think it would change at all what should have happened here. Arguably, if the husband were entitled to some credit for it, so to speak, and it was, well, if it was a non-marital asset that he used to satisfy marital debt, then he would have been entitled to the wife's half of that debt that he paid out. Other than that, it is irrelevant, and I respectfully submit that doesn't matter, because what's important to understand is, and it is clear in the final judgment, which ratified and incorporated the parties' settlement agreement, is that money was paid out prior to the divorce, prior to the dissolution of marriage, and that the parties agreed that beginning in August of 2001, they would be equally liable, prospectively, for those debts. So that payment had already been made prior to that time. So there's nothing in the final judgment that suggests that the former husband, that even suggests the former husband should get some kind of credit for that. And the analogy that I would draw is this. If the parties had a credit card debt, there was a marital obligation, and let's say it was $10,000. And let's say prior to the final hearing, prior to the dissolution of the parties' marriage, but after separation, the husband with income that was solely his paid that entire debt. Well, if the husband then proceeded to final hearing and did not establish a credit for that, did not get his $5,000 back, then he forever waives that claim. And that's really, in essence, what the husband has been allowed to do here. Approximately 5 years later, he comes in and says, well, I paid that $135,000 out, and now I need to get it back. That's what he's done, because there is no reservation in the final judgment for that. There is no determination that he's entitled to credit for that. And in fact, the language, clear and unambiguous language of the final judgment, following the parties' agreement, is in fact that the $135,000 was prior to the time in which the parties became equally liable for these obligations.
So you're, just so that we're on this, I want to make sure I understand the argument.
Yes.
Your argument is that the agreement and the effective res judicata and all that are clear that because the agreement says that the debt and amount of money coming in is going to be split and shared equally from a certain point forward, and makes no provision, does not allow the husband to get any kind of additional credit for money spent for anything prior to that, that's the end of the case. He shouldn't get credit because the agreement doesn't provide for it, period.
I really think it's that simple.
It's that simple. And then your secondary argument is, okay, if he's, for some reason that you can't see or understand based on the agreement, allowed to go back and take one item and say, okay, I should get additional credit for this, then you're saying that if it was a marital asset, it would have been a wash anyway. He used a marital asset to pay a marital debt. There's nothing else to credit. He's gotten the credit, right?
That's correct.
If it was a non-marital asset and he gets to go back and reach back and bring it forward, even though the agreement doesn't provide for that, then even best case scenario for them, if they're allowed to do that, he should only get credit for, because he paid a marital debt and half the debt was his, he only gets credit for half of the payment, not the whole thing. So that's your fallback.
That's correct.
And that's it. Okay.
The worst case scenario, so to speak, for my client is that that half of that $135,000, which is $67,500, that half of that is hers. Now, again, I don't believe that position. I don't think that's the correct position, but I did raise it because even under the logic and reasoning that the trial court apparently followed, that would be clear from our perspective. The other thing is that, again, the posture that this matter came before the trial court was that the former wife was seeking half of the proceeds from the American Health Care settlement. Now, remember, this $135,000 we know was paid before any part of the American Health Care proceeds were received, several months before, almost a year before, and was from the sale of OCF stock. So the $135,000 did not that the former husband used did not come from the American Health Care proceeds. It came from this sale of stock prior to the dissolution of marriage. Somehow, the trial court, and this is reflected in the order that was ultimately entered, felt as if the former wife had the burden to prove to the trial court that she was entitled to this extra money. And our position is, and this is in the brief, that is backwards, because the wife was simply seeking half of the proceeds from the American Health Care, and that was documented. There's exhibits in evidence, Exhibits 1 and 2, which are in the record at pages 208 and 213. Excuse me, 208.
Well, as I understand your position on that point, there really is nothing to prove. I mean, the only fact in dispute, if it's relevant at all, and it isn't according to your primary argument, is whether that $135, whether the stock was a marital or non-marital asset. I mean, because everything else we all agree on. We know the amount of money from the American Health Care. We know it was supposed to be split equally. We know it. So the only factual matter about which there's any disagreement is whether that stock was marital or non-marital. And your position is it doesn't matter.
That's correct. And in fact, if you
so the burden of proof isn't an issue.
Well, the trial court specifically found in the order, and I'm quoting, that the court finds insufficient evidence as to the former wife's claim for another $135,000. And again, I believe that there was, if there was a burden about this $135,000 at all, it was the former husband's. Because what happened was the proceeds had been received by him. The former wife was finally making her claim for half, finally trying to get some of that money, and the former husband came in and said, well, I paid attorney's fees out and I paid this out, and he listed, included in these list of items, is the $135,000. So as the moving party, if you will, on those credits, it was his burden, not the former wife's burden. So if the trial court was confused or does not feel there was sufficient evidence about this $135,000, and if it was relevant whether it was marital or non-marital, then the former husband failed, so to speak, not the former wife. I do want to very briefly, before I reserve my last 5 minutes, address the two issues raised on cross-appeal, or two of the issues raised on cross-appeal. There's an issue regarding a credit for $25,000, or a claim by the former husband for $25,000. The appellant filed a motion to dismiss. This court denied that without prejudice. I'm going to again raise that. There is no order that has been entered which addresses that claim by the former husband. Our position is, therefore, that it's not ripe for appeal. As to the other issue raised on the cross-appeal, and this is set forth in the brief, the answer brief, it's basically been conceded. There was attorney's fees that were used by the former, or paid by the former husband from the American Health Care proceeds to an attorney in Jacksonville who was handling all these matters. And the former wife at hearing half-heartedly argued, concededly half-heartedly, argued that the former husband shouldn't get credit for that. That shouldn't be deducted from the settlement proceeds because the former wife was not informed and involved as she should have been. The flip side of that is she obviously benefited from the assistance of the counsel. These approximately $2,300 in fees which are raised by the former husband in appeal had to do with an unpaid portion of those fees. And if the original fees which were paid should be credited to the former husband, then the $2,300 should be equally borne by the parties. We would concede that. And that was the position taken at the hearing. So I'll reserve my remaining 5 minutes if I may.
Thank you, sir. Mr. Farley?
Your Honor, if it please the court, I'm Joseph S. Farley, Jr. from Jacksonville, and our firm represented Dr. Lester in the divorce, although my partner, Harry Mahan, was the one that was opposite Elliot Zisser. He died in the fall of 2003, so I had some bit of familiarity with the case, but not the familiarity he did. And I agree. I think we did have an agreement that the $2,300 owed to Betsy Cox was simply an oversight on the court's part, and we were both in agreement that.
Let's talk about the $135,000.
Okay, I have two main positions regarding that.
Well, let me ask some rather pointed questions here so I can try to understand this. Was there $135,000 that netted from the sale of the OCA stock?
Yes, sir, that's my understanding.
Okay. And is that the same $135,000 that your client took as a credit against the proceeds from the America Healthcare matter when it was resolved?
Well, I think that gets I think it's a little broader than that. There were these three litigation issues going on. They were treated as kind of a ball of wax business venture or whatever by the parties. They were tied together in that there was no, except for the first one where there was the settlement and there was the money coming in.
Okay, well, let me try to unravel the ball of wax a little bit. When he sold the OCA stock, he got $170,000, and after taxes that netted $135,000, and he paid that to DPI. Am I right so far?
Yes, sir.
Okay. Then he settles the American Healthcare matter. He resolves that, and he gets a pool of money, and he prepares an accounting. And in that accounting, it lists an expenditure of $135,000, and it has a date on it. The date is 12/11/2000, and it's a payee of DPI. Is that the same $135,000 that was paid from the proceeds of the sale of the OCA stock?
Yes, sir.
That entry on his accounting date at 12/11/2000, check number 6045 for $135,000.
I believe so.
Okay.
And what I was going to say about that is that the doctor paid his half of that money to DPI. He paid the wife's half of that money to DPI. All right. And later, yes, he did take credit for that whole $135,000 out of.
Well, doesn't your whole position hinge on whether or not he was entitled when he sold the OCA stock to keep the whole $135,000?
Whether he was entitled to keep it?
To keep it. In other words, was it his separate asset as opposed to being a marital asset? Isn't that your position?
Yes.
Okay.
Yes, sir.
But the contract required him to take that money and apply it to a marital debt, right?
The contract.
Paragraph 11.
The settlement agreement, is that?
In the first full paragraph says that from the sale of the OCA stock, he's getting $170, and there's going to be expenses and blah blah blah, and it has been paid to DPI, right?
Right.
So when they signed the contract, didn't he acknowledge that $135,000 was properly applied to pay a marital debt?
Well, for whatever reason in the contract, I mean, it had been done.
Right, but I mean, he didn't reserve any kind of credit for, paying a marital debt with non-marital assets or anything like that.
Well, the marital settlement agreement, again, could obviously have been worded better, but it was, as was said, parties dealing with facts they intimately were familiar with. And to me, a common sense reading of that paragraph 11 in toto is the doctor is saying, look, I already paid $135,000 of that.
But he paid it from a particular pool, according to the contract, right? It was the OCA pool.
Right, definitely it came from the OCA stock, so
Yeah.
OCA stock. Mr. Zisser is, yeah, you say you paid it. You're representing that you have already paid that money. So that wording is in the agreement. Then there's nothing in that agreement that says she's entitled to 1/2 of that payment. That paragraph 11.
1/2 of the OCA stock sale.
Right.
She's not entitled to 1/2 of that.
It does not say she's entitled to anything.
Well, but it says he's going to use it to pay a marital debt with, I mean, isn't that good enough?
Yeah, and it was done. It had already been done according to his representation. So at that point,
Well,
nobody seen the cash.
if it says, which it does, that he has used this money to pay this marital debt, and in the future, all proceeds from this settlement are going to be paid equally to the husband and wife, minus whatever debt is paid in the future, which is the way I read it. Where does that leave room for him to take another credit for money that he's paid toward a marital debt? I'm just not following how this contract allows for that credit. Second credit.
I don't know when you take out that contract. I'm just looking at the marital settlement agreement.
Well, that's what I'm talking about, yeah.
Okay, well, it very specifically in paragraph 11 protects the wife on this, and there's no mention of her being entitled to 1/2 of that $135,000 that it says the doctor paid. She's got future
But he
protection.
used the money, the contract says that he used the money to pay a marital debt,
Okay,
right?
yes.
And the contract doesn't say that he gets some sort of a credit for that at some point in time.
Well, again,
I mean, isn't it a fait accompli? Once he pays a marital debt with the money and doesn't reserve to himself some sort of reimbursement from marital funds, it's a done deal, isn't it?
I don't know. It's in there that he made that payment. It's in the marital settlement agreement.
Right.
And there's no requirement that she is entitled to a credit on that payment he made. In my mind, it was protecting the doctor.
I actually think that he's got to reserve the right to a credit if he's paying a marital debt with it. It would seem to me that if he's taking the position that it's non-marital and he's using non-marital funds to pay a marital debt, it would be incumbent upon him to reserve some sort of a credit against that from future proceeds.
Again, all I can say is that it is in the marital settlement agreement. And we weren't there, and we don't know exactly the wording that was discussed or the reasons therefore. But somebody, in my mind, is trying to upset the marital agreement. And I think, I mean, this is 2 years later. There was no fuss about that marital settlement agreement. Then there was this first motion to enforce that once the doctor explained all the numbers, that went away as far as the missing $250,000, and then this new theory came along.
But there's the end of paragraph 11 says that there's litigation regarding another DPI matter and an American health care matter that aren't yet resolved. It says the parties shall equally be responsible for the indebtedness, which is a DPI matter, and equally benefit from the American health care payout, which was anticipated. I mean, that's what it says, correct?
Yes, sir.
Okay, and the wife is simply saying, I want my half of the American health care payment, less the amount that was paid for the DPI matter as set forth in that last part of paragraph 11. And it's the husband that's saying, well, no, but I want to get another credit for money that I spent before any of this. So I'm having a hard time following how you're saying the wife is trying to upset the agreement when all she's asking for is her half of the money that the agreement provides she'll get.
Well, to me, it's saying that the husband out of non-marital funds paid $135,000. And it's all in their litigation.
says that?
Where does it say that was non-marital funds?
Doesn't.
Okay.
How do we know that it's non-marital funds?
I don't.
I mean, your position was that the wife had the burden to show that it was marital funds.
In order to sustain their argument, I think they had to show that it was marital
I
funds.
mean, ordinarily, just as a matter of ordinary, domestic relations law, when non-marital funds are used to pay a marital debt, there's a presumption that it's a gift. It's done. You can't, unless the owner of the non-marital funds has made some sort of a reservation or made some sort of an express agreement that he's going to get reimbursed. It's the conversion of non-marital assets to a marital asset, right? I mean, you're a divorce lawyer, right? I mean, isn't that the way it is? I take my money out of a separate bank account and I pay a joint debt that my wife and I own. I mean, I can't be heard to complain about that later, right?
Well, and in obviously, I'm biased, but in my thinking of it is that when you take that paragraph 11 and you see that the wife is protected on this future stock option or whatever there were like 3 or 4 things there that were secured to the wife, and there's nothing in there about she should be able to get credit for half of that $135,000 payment that is definitely mentioned in there, and mentioned in there for a reason. Then by including the specific things and leaving that out.
So are you now you said that she's not saying that she should, or you're now talking about half of the $135,000. Are you conceding his last point that the best it can get for your client is credit for half of that?
No, I'm just saying that the doctor paid the whole $135,000. He paid his half. He paid her half. That's our.
So why should he get to deduct the money that he used to pay his half now from her payment?
The way they treated this litigation was one ball of wax. You take the expense out of it. When there's a profit, whatever the expense was, you subtract that. If you're in a minus situation, then y'all both have a debt. If there's a profit situation, then you both split it.
But there's 2 pools of money here. There's revenue from OCA and there's revenue from the AHC. So there's 2 pools of money. You only get the debt one time, right? How do you get the debt twice? How does he get $270,000 credit when he's only written a $135,000 check? That's what I don't understand.
And I
don't understand that either. So if you could explain that now, it would be helpful.
I'm having a hard time understanding how he got a $270,000 credit.
How he what?
How he got a $270,000 credit.
Well, because he took from the sale of the OCA stock, one source of revenue of assets. He paid $135,000.
And in my mind, right at that point, he's at a minus 135.
He eliminated his own debt.
I guess that presupposes that the OCA stock was a separate asset and that he was advancing the money from a separate asset. And, that's where I think your agreement is lacking.
And all I can say in defense of the trial judge, I agree there was insufficient evidence for him to be able to determine what they decide in the way they're asking him to decide. And I don't know that there ever will be, but there was opportunity to take the doctor's deposition and determine whether that was a family inheritance he had or what.
But if I take a family inheritance, let's say I got $100,000 and I keep it in a separate account, and I write my wife a check for $50,000, and I don't say that it's a loan. I just write her the check for $50,000, and she goes and spends it. I can't go back and get that money back from her in a dissolution, right? I mean, that's a gift, right?
That sounds like that might be a gift.
Okay, well, why wouldn't it be any different if instead of handing her the $50,000, I wrote a check for the $100,000 to pay off a marital debt?
Because you've got that 3 convoluted litigation situation where are we going to profit or are we going to lose? And I'm just saying that he fronted the $135,000 and later recouped it.
Well, but your theory, I think, when you say he fronted it, your theory presupposes, I think, that the $135 is a non-marital asset. doesn't it? Because if it was a marital asset, then he didn't front it at all.
Right.
Right.
And there's no evidence.
And
About
we
it.
don't know.
Right.
So if he's the one that's seeking the credit, wouldn't he have to demonstrate that? Or, I guess more fundamentally, wouldn't he have had to reserve that credit in the marital settlement agreement? If his theory was, I've taken, at the time the MSA was drafted, if his theory was, I've taken a non-marital asset and advanced it to pay a marital debt, and I want credit, assuming that all these other things work out the way we hope they will in the future, didn't he have an obligation to put that in the agreement at the time the agreement was entered into?
I don't believe so, and for the reason I keep saying, the doctor testified that those three cases were kind of an ongoing thing, and
I absolutely agree with you, but the question is, still, it really comes down to what Judge Torpey just mentioned a minute ago. To accept your position, we would have to assume, A, that he paid the $135 with non-marital assets, and B, that he did not intend that to be a gift.
Right.
And I think, and you know, while common sense would say that chances are if the parties are in the throe of a divorce, he's not just going to make her a $67,000 gift. As a matter of law, we can't make that assumption. So, as Judge Torpey said, if I take a non-marital asset and without any reservation or provision pay a marital debt, isn't there a presumption that that's a gift?
I guess it depends on the circumstances and what was going on at the time, and that's...
Well, no,
like
I'm asking about the specific case. I'm just saying, doesn't the law presume that that was a gift? And maybe you can come in and argue to the contrary, but isn't there a legal presumption that if I take non-marital assets and pay down a marital gift, that there is a presumption of a gift? Not an irrebuttable presumption, but a presumption.
In general?
Yes.
Yes.
Okay.
In this specific case, though, I think the parties understood what they were doing, and it was, is there going to be a profit, is there going to be a loss? We know we're going to pay the expenses first, and we'll see what comes up in the next 2 years as far as the ongoing litigation, and if it's a debt, it's a debt, but they intended for the expenses to be paid, and I'm just saying the doctor paid $135,000 of that, and I think he was entitled to a credit for it.
Okay. Thank you very much.
Thanks, Todd.
Counsel?
Let me ask you about the point on cross-appeal regarding the $25,000,
Yes, Your Honor.
the alleged loan from the purchaser of the marital home. It doesn't appear that the trial judge ruled on that at all, and the question I have is why shouldn't we at least, and I think that, you know, given the evidence and given the suspicious nature of the transaction, the trial judge could have gone either way on that issue. If the trial judge accepted your client's testimony, he could have said it was a loan, it wasn't part of the purchase price, so no credits necessary. But given that there's no ruling, why shouldn't we send it back and say, make a decision, rule?
Well, I agree that there is no ruling, that it was presented to the court, the trial court. The only argument I could make, and it's suggested, is that any relief not granted is denied. But the truth of the matter is, and I hope I'm not going outside the record when I say this, when a motion for rehearing was submitted in this case, and I know because I did it was communicated to the court that an order had not been entered on that motion. And I believe an proposed order was even submitted. It was never entered, and I can't explain why it wasn't or why the trial court didn't.
So would you agree that it would be appropriate to remand and say you need to decide this issue?
Well, I believe that there was evidence presented, and I think it's possible to draw inferences from some of the comments the trial court made about how he intended to rule, but I would agree that it has not been ruled upon, and I don't know that there needs to be further proceedings or anything like that in terms of additional evidence. But
right, just what's your decision?
But a remand, I think I would have to concede that would be appropriate, yes.
Okay.
I want to be clear, and I think it is clear, but that the former wife is not and has never asked for half of the OCA stock sale. She's only asked for half of the American Healthcare proceeds. And these exhibits that are in evidence, the first page of Exhibit 1 is Record 101, and the first page of Exhibit 2 is Record 208. Record 201, the Exhibit 1, shows that the first payment was received from American Healthcare to the trust account of the husband's attorney, former husband's attorney, on July 13th of 2001. As is also reflected in that same exhibit at the fourth page, which I believe Judge Torpy picked up on, was that the date of the payment to DPI that we're arguing about was December 11th of 2000. So it was some 8 months before the American Healthcare matter was resolved, and in between that time, the parties had entered this agreement. Clearly, that payment was not made from the American Healthcare proceeds, and again, I believe that really this is resolved on res judicata, and cited in the brief is the Davis versus DeGiust case, which is a Florida Supreme Court case, which basically stands for the position that when the property rights of parties are litigated in a dissolution action, then the entry of the final judgment bars forever all subsequent litigation of such matters, and that's our position is that's what the former husband is trying to do here, is to relitigate or to re-raise the $135,000, which is.
Tell me what the net result of your appeal should be in your mind if you win.
I would request that.
How much net dollars does your client get?
An additional $67,500. And that would not account for the 23 or half of the $2,300 that we've conceded in essence that the trial judge for some reason didn't include in the order, and that obviously would not account for this $25,000 depending upon what the trial court ultimately does. But with respect to the American Healthcare settlement and the ruling on the second motion to enforce, which is what the former wife was advancing in front of the trial judge, it would be $67,500.
Yeah, you're just arguing that the $135,000 was not a legitimate expense against this pool of money, right?
Exactly. And there were other expenses that were set forth in the former husband's accounting, some of which we conceded, some of which we didn't, but certainly that one was the one that we focused on as clearly not being something that should be credited against the American Healthcare proceeds. It really is irrelevant to the distribution of the American Healthcare proceeds, is and was our position. There was some mention made by opposing counsel, and there's some language to this effect in the order that about the intent of the parties. There's no really need to get into the intent of the parties when the language of the final judgment is clear and unambiguous, and it is clear that the parties were to be prospectively August of 2001 forward to be responsible for these debts, and it's very clear that there's no provision for a credit of any sort or a reservation for a credit or consideration of such for the former husband. Thank you very much.
Thank you, counsel. Thank you both.